Good morning, everyone.
Good morning.
Susanna, I've made you host, so you should be able to show your...
Thank you. I will do that. Just
you see it at your end, okay? And then when you switch over, when you finish your slides, Susanna, if you just switch over, you can hover over Carly's video screen and you'll see the three dots, and then you can make Carly host, so that she can then take over with her slides, if that's okay.
Yeah, that's okay.
Okay, so we'll make a start. Morning, everybody. I'm Rob Lord, one of the partners at Cowgills. Welcome to the second of our Brexit webinars. I'm afraid to say 2 weeks down the line, we're no further on from where we were at the last one. Boris is obviously imminently about to jump on a plane to Brussels. We feel as though we're at a bit of a stalemate at the moment, with only a few weeks to go. So let's see what happens. We have to work, I guess, on it being a no deal at the moment, but let's see if Boris can work his magic or make things worse, even going over to Brussels. So as you saw in the invite, thanks for joining us. I think we have about 25, 26 joining us today, which is fantastic. I'm going to be handing over shortly to Susanna. I'm joined by two panel members today that you'll have seen from the invitation. One of which, as I said, is Head of International Trade, which is Susanna Cordoba at the Greater Manchester Chamber of Commerce. Susanna has kindly agreed to join us to talk about really what support the Chamber can offer to businesses now, pre and post Brexit. And also, we'll talk about various different things for about 15-20 minutes, one of which is what is the impact of a deal or no deal. We'll then go on to Carly Hale, who's a Senior Associate at Knights Solicitors in Manchester. Carly is an immigration specialist, so we'll talk about the immigration changes coming up, visa changes, and in general, again, forward planning for businesses going forward from next year. So if you have any questions, I'm sure quite a lot of you will have been on our seminars before, but if you have any questions, I'm sure you're all very familiar with the chat function at the bottom. I'll be monitoring that as we go along. If you have any questions throughout, can you please make sure that you pop any questions in the chat box, and then we'll make sure that we acknowledge those at the end of the webinar. We're going to share these slides. So there's quite detailed, some of the slides I had a flick through earlier. So rather than you having to scribble away, don't worry too much, because we will be making sure that we will email a copy of these slides out after the event, and obviously Susanna, mine, and Carly's details if you have any questions. So if you wouldn't mind just making sure that all your microphones are muted, that would be great, and I'll hand over to you, Susanna.
Thank you very much, Rob, and thank you for inviting me to be part of today's webinar. So just a quick thing, just cover a couple of things. So for those who are not quite aware of who we are and what we do, I'll just give you a quick glance of that, and then I'll just go straight over about the service and support that we are offering to companies in this time. So we are actually the largest accredited Chamber of Commerce in the UK, and that's in terms of our membership base. So we have nearly 4,500 members, and that's across all sectors and sizes. So we represent about 5% of the business population in Greater Manchester, and representing about 460,000 employees all over. We actually cover 10 local authority areas in GM, but we do have members across the UK and a handful from overseas. Our top 3 sectors are within the manufacturing and engineering sector, property and construction, and business and financial services. But obviously, we do have representation from all of other sectors, going from hospitality to digital and IT, just to mention but a few. We are members of the British Chambers of Commerce. That is our umbrella organization. So as I mentioned, we are 53 accredited chambers across the UK. We are also members of the International Chambers of Commerce, the Institute of Export and International Trade, and the Caribbean Council. And as you can see, in the last few years, we have received a few accolades, which obviously we are quite very proud of. We are not-for-profit, we are private business support organizations, and we are non-government. So I think that's important to mention. Before I go into detail on the slide, obviously one of the main things that we do as a chamber is generally lobbying and being the voice of the members that we represent. So that's a huge part of the support that we provide to businesses. We also provide support on the skills sector. We work with a number of partners, both here in the UK and overseas, to help companies to both thrive in the domestic and international markets. In terms of international trade, we provide support in each of the stages of the internationalization journey, as you can see in the slide. I'm not going to go into much detail because you can visit our website for more information. But just to mention a few, is all the way from helping you to get ready to export, or in this case, for Brexit, to provide you with more specialized support through some of our partners, emissions, market events, a lot of the foreign exchange support, export documentation, customs declaration, which is one of our newest services. So that's just kind of in a nutshell in terms of the overall support that we offer. And now if I just go into more detail about the services that we've been doing in terms of Brexit. So one of the most important areas that we've been doing is research. So that's through our members, the feedback that we've been getting through them. What is the areas that have been impacted the most in terms of the guidance that they receive, in terms of what actions they've taken to prepare. And that's something that we've been feeding to central government, to local government, to ensure that they are addressing those challenges. As we know, even, I mean, Rob mentioned it at the start, is less than 24 days away to the end of the transition period. And unfortunately, we still have very limited guidance in a lot of the areas that businesses need to know in order to prepare. So these are just a few examples of the things that we've been doing. And some of these things, research has been in partnership with some other organizations. So this is, I mentioned earlier, another area that we do. Obviously, with the research comes the lobbying part. So this is just talking to government, making sure that the voices, the concerns of businesses are being heard. We have a Brexit hub within the British Chambers of Commerce, and we also have a Brexit hub with the Greater Manchester Chamber. I think this is one of the most important pieces of work that we've done, and it's just going through all the guidance that has been provided by the UK government, and understanding what is clear, what isn't, what needs more detail behind. And this is just an extract of the one that we just launched literally yesterday. This is our guidance dashboard, which indicates what are the questions that remain unanswered or with lack of detail behind the UK government guidance. The one before this one was launched back in September, and we had 26. The one that we launched yesterday has 24. So we just got better detail on 2 questions. So that can give you the scale of the issues that we're facing. Obviously, in terms of trade, a lot of, sorry. Okay. So in terms of trade, you see that it's not just trade, it's obviously digital. It's about the funding. I mean, we represent businesses across all sectors, from private to charities, you name it. And we understand, especially in terms of trade, even though we get a few of the, you can see in that slide, there are a few things where we got better. So they got the green light. We still have some in red light. One of them is the rules of origin, and some of them remain in amber. So it's a lot to be done. And I think we will continue to monitor progress, what is being given by government. And this will be available through our GMCC Brexit Hub, which I hope I'll show you a bit how to navigate through it in a bit. Other part of what we've been doing is obviously keeping people informed. Trying to break it down is the amount of information is overwhelming. We know SMEs especially are just as tied up with the day-to-day operation to go through thousands of pages and the Gov website trying to find the one piece of information that is right for them. I'm not saying it's all sorted through our GMCC Brexit Hub, because to be honest, it's loads to go through. but at least we're trying to keep you informed with the shorter pieces of information that might be relevant to your business. So we have some blogs that we've been updating in our website. We've been doing end of transition webinars, free for both members and non-members. We've done 4 of them, which provide when the new UK border control was launched, the Northern Ireland Protocol, any updates that we have gotten that we need to get out to members ASAP. That's where we've been doing that. And the latest one will be with HMRC, which I hope that's what it says on the tin, is Ask HMRC, and is due to be happening next week. If you go to this page in our Brexit Hub, then you'll be able to see the recording of the webinar, the slides, and if there is a Q&A section, then they will be there uploaded. I will recommend that you do take the time, because some of the questions that have been posted by other companies might be relevant to you and may help with some of the queries that you might have for your own business. So deal or no deal? I'm afraid that is like Rob said, it's 24 days and we still do not know. I mean, today, the news indicated that it seems there is a bit of light in terms of the internal market bill, where the UK might make some concessions on that one. We know the internal market bill is very controversial because it's actually breaking some part of the Northern Ireland Protocol. But this will have a knock-on effect as well on the US-UK trade negotiations, as we know that the elected president is kind of very pro Northern Ireland, maintaining the Northern Ireland Protocol. But other significant issues remain: fishery, state aid, level playing field. So let's hope that today, as it was mentioned in the morning by the president of the EU, they might get into some sort of agreement. There is a bit of light in there, and just trying to be positive, I guess. But even if there is a trade deal, we know it's not going to provide all the answers to everybody, because there is so much behind, and the practicalities that go behind that agreement, that we might find ourselves in a bit of disruption anyways in January. So just those were the latest tweets from both Michel Barnier and David Frost, just to keep you up to date. And the deal or no deal, we have to understand that some companies have been under, I don't know, thinking incorrectly that if there is a deal, suddenly everything will be okay, and that's not completely true. There will be some pros, obviously, of having a deal, but there will be some. The fact is that we will have a border, and with a border will come a series of customs, new customs processes, new paperwork that both EU and UK companies will have to align with. So that is worth noting. And then another area where we've been doing loads is in the training and just overall preparation. So last year we got a bit of funding from BASE, and we were able to launch the Brexit Hub. We were able to do a few events and training courses for companies free of charge. We tried to maintain that after the funding finished, but obviously a bit more difficult. But what we did do, and we'll continue to do throughout 2021, is we launched free master classes. These are 1 hour, easy to digest webinars where we touch on the basics of export and import. Obviously, we do give you a bit of updates on Brexit if we are touching on export or imports, some of the new customs procedures, etc., etc. So stay tuned, because we will be launching further schedules in the new year. We had over 500, more than 500 delegates attending all over the region and beyond. And the last one in our series is actually taking place on Thursday, and that's going to touch on VAT. And these are free of charge, both for members and non-members. We have obviously continued to deliver our training courses. So we deliver about 10 accredited courses by the British Chambers of Commerce. we find that most of the companies and their processes of preparing for Brexit have been lacking some of the basic knowledge regarding trade, from getting clarity about Incoterms, which is one of our courses, or if they are using a special customs procedures such as inward processing or out processing, export documentation and processes. So these are a more half a day or full day training courses that we offer through our accredited line, but we also offer non-accredited courses, and that includes our how to complete customs declarations. This is one of the biggest changes that we will see in the movement of goods between the UK and Europe. So the fact that all companies will have to complete customs declarations for the exports and for imports. So this is a one-day course, and you can tap into HMRC grants in order to cover the cost of those trainings. As I mentioned before, we also been doing a lot of end of transition webinars. We have gathered more than thousands of delegates across the UK. We've been doing a lot of joint events, both with UK and EU partners to address both UK and EU companies in terms of preparation. We've delivered more than 40 personalized Brexit readiness report, which is just, we just touch on the basics of the preparation steps that every company exporting or importing goods should be considering as a way to prepare for the end of transition period. And we deliver more than 50 hours of personalized support through our team, just answering questions from companies about the practicalities of trading. So we have also launched a series of transition services. This is tapping into our network of external associates. This is working with experts on customs and other areas of trading. And we've been offering audit services. Obviously, with the pandemic, we moved the on-site ones to digital. They take place via Zoom or Microsoft Teams. And our experts go either through the steps that you've done to prepare for your business, or if you have more specific questions regarding your preparation, then they can also address that. That's a 3-hour audit. We also put together a package which we call the Digital Get Brexit Ready, and that includes the Brexit readiness assessment and go through the report with a member of our team, plus the audit with the expert, plus the review of custom declaration box by box, so you understand what this new requirement is, or if you already are familiar with customs declarations, just to make sure that the ones that you've been doing are being filled correctly, because ultimately it's down to you any errors that might happen, even if you appoint somebody else to do it on your behalf. And then you'll get a free complimentary customs declaration done by our team, so you can test our services. As I said, we just done the customs declaration brokerage and training services. So we do both the export and imports, and we can also offer bespoke training courses to your teams. We've done a few for freight forwarders, for some companies that just want their staff be more aware and knowledgeable about the kind of things that are required for customs. Documentation, obviously we are the leading provider of export documentation in the North. We provide about 30,000, nearly 40,000 export documentation a year, and that includes certificates of origin, ATA carnets, which are going to be a new requirement for temporary exports from the 1st of January. The replacements, obviously we've been working with European certificates of origin, so we'll now be offering the UK certificate of origin. There will get replacements for those who might be familiar with the EUR ones, so we'll have a version for the UK. Arab certificates of origin, import certificates, so we can help you with that, and general certifications of documentation such as invoices, packing lists, and so forth. Bespoke advice: if you think that the other services are too lengthy, they just are too much for the requirements that you have, and you just happen to have very specific questions, whether it's on VAT, whether it's a custom procedure, whether you need help applying for a new export license or the new customs procedure, simplified procedure, then we do have a number of expert advisors that can help, and obviously members do get a preferential rate. And lastly, I'm not sure if this is gonna work, but this is our Brexit hub that you can visit. And let me see if it works in terms of the video. So yes, so I'm just gonna be quiet and just walk you through it. So that's our main page. That's the main areas where you'll find information, some of the events, and it's not only from the chamber, it's also across all of the partners that we work with. Some of the news that I mentioned before, the one I said about the 24 unanswered questions is already uploaded in our website. Some of the key areas that will experience some change across the board. EU guidance, this is from all the trusted sources, from the UK, the EU, the WTO, Chambers of Commerce, the MCC, and other partners. So we do have one part for frequently asked questions. The Brexit readiness assessment that I said, this is exclusive for exporters of and importers of goods. Unfortunately, we are not doing much with services, but and this is just some of the free resources that you might be able to tap into. We have useful links where we have been gathering lots of the sector advice from government and other sector trade associations. So for example, if you're in recruitment, if you are on food and drink, chemicals, aerospace, we try to put all the links that we found that we thought it will be useful in that section. So as I said, that's our Brexit hub, and I hope that that will provide you a full overview of how we can support businesses. I'm happy for these slides to be shared, my contact details as well. But if anybody has any questions, I think we have a bit of time at the end of the presentations. So that's it for me. So I'm now just going to stop my presentation and stop sharing so Carly can do her bit. Thank you.
And you've made Carly the host, have you, Susanna?
Yes.
Just ask a quick question. Thanks very much for that, Susanna. It was really useful. Just ask a quick question. There seem to be quite a lot about personalised reports in there and bespoke advice. I presume with members, you're literally spending some time with them, discussing their own sort of businesses and situations and requirements, and then delivering those reports. And also, you mentioned doing some training for the staff as well. Is that right?
Yeah. So what we're doing with the Brexit Readiness is an online survey. All businesses can complete it. The report itself is free of charge, so you'll get it whether you're a member or non-member. However, if you want to have somebody to go through the report and answer some questions, that's a chargeable service.
Okay, that's great. Are you okay, Carly? Are you ready to?
Yeah, can you see my slides?
No, not at the moment.
Oh. It's a good start.
I think it just should be an option at the top, is it, just to click share your screen? Is that right?
Yeah. Sorry about this. Yeah.
Unless it's easier just for Susanna to carry on flicking through the slides from her side.
Yeah, I think that might be easier. Do you mind doing that, Susanna? Susanna?
Sorry. I think I need your slides, so I don't have them. Unless, let me just check something.
Do you have them, Rob? If I can just, because I don't, it's not letting me share them. Sorry.
Yeah, just make me host. I think I had them.
I do have them. So if you want me to,
Okay.
Oh,
post
brilliant.
them,
Thank you so much.
let me just share. Wait a sec. Okay.
Perfect. Okay, apologies for that. So I'm going to talk about the immigration changes that are affected by following the end of free movement, which will come into effect from the 31st of December. The agenda that we have today is the UK immigration system and what will change, EEA nationals working in the UK, the significant costs involved for anybody who will need to employ an EEA national from January, and forward planning for the businesses, so what you should be considering. These changes arise from the Home Office when they published the white paper, and they've been stemming from discussions from December 2018. And it's controversial and complete overhaul of the immigration system. So confusingly, we do have what's called a points-based system, but this one is more going to be more aligned to the Australian system, and I will come on to that in a moment. Just onto the next slide. What will change? So following the end of free movement, the system will treat EEA and non-EEA nationals the same. So currently, as you'll be aware, if you wanted to employ an EEA national at the moment, they could come to the UK, show their passport, show their ID card, and essentially could work for you, requiring certain conditions are met. Previously, EEA nationals, that's what's called exercising their treaty rights. So now an EEA national will be required to obtain what's called a skilled visa. And this means that they'll be subject to meeting minimum requirements. So in relation to skills, in relation to salary threshold, the additional costs on an employer can be £624 a year for the immigration health surcharge. Skills charge is £1,000 a year. You've got the application fee. You've got additional compliances. So it can cost around £9,500 to £10,000 if you were employing somebody for up to 5 years. Employers will still need to show what's called a genuine vacancy. So what we mean by that is the role can't just be created for an EEA national to come to the UK or indeed a non-EEA national. The skill level, which is a welcome change, has dropped from RQF level 6, which was the equivalent to a degree level. It doesn't mean the individual has to have a degree. It just means that's what the role had to be. That's now dropped to RQF level 3, which is around A level. The removal of the resident labour market test, I'm not sure if you're aware of this, but previously you had to advertise the role for 28 days to see if a settled worker could be found for the role. That's been abolished, but just to emphasise, it does still need to be a genuine vacancy. So we anticipate that the Home Office might ask for evidence of how you selected the role. Was there a need for it? Was it advertised? Albeit it doesn't need to be in the strict immigration Home Office format. The salary has reduced. It's currently £30,000 a year, or the SOC code, whichever is higher. Now, the SOC code is a list of jobs set out by the Home Office. That's been reduced to £25,600 per year. But you can also do what's called tradable points. So if your role is, for example, on the shortage occupation list, or you are a new entrant, which means you're age under 26 when you're applying for your visa, or you're signing a certificate of sponsorship for less than 4 years, you can trade some of those points to have the salary reduced, but it can't be lower than 20,000. I think it's 20,400 a year. So that's welcome changes for employers in the UK. However, that will be offset against the obvious higher cost of employing an EEA national in the UK from January. So EEA nationals and family members, sorry, next slide, thank you. They can still enter the UK using their EEA passports. They can, work and study. They need to be living in the UK before the 31st of December. If they are, they have until the 30th of June next year to apply under the EU settlement scheme. Now they'll be granted either settled or pre-settled status, and I'll come on to this onto the next slide. and they don't get to decide which status they require. Just an important point to note is that employers cannot request the individual to see that individuals have applied under the scheme until the 1st of July next year. So this does raise some questions around the right to work checks. Currently, until the 30th of June next year, you still check an EEA national's passport or ID card to show that to obtain your statutory excuse if you carried out the right to work check correctly. If you have somebody working for you from, say, the first week of January, but they'd say that they were in the UK before the 31st of December, you still check their passport or ID card. Now, it's the onus is not on the employers to say, were you in the UK before? I need to check your documents. I need to check if you were in the UK before. Not at all. If there is reasonable cause to doubt that you were aware that they were in the UK. So, for example, if you have email trails saying, you know, I'll be in the UK, I'll be arriving on the 2nd of January, for example, you'll then have reasonable cause to believe that that individual was not in the UK before the end of the transition period, and therefore they should have entered the UK under the skilled worker visa and have to incur these additional costs. So that's just a point to note when you are carrying out the right to work checks. We've had confirmation from the Home Office that there should be updated right to work checks around April next year. That's not to say it will be definitely in April. It's just that's a guideline of when the new right to work check should come into new right to work check guidance should come into force. You have a duty to not to discriminate, and that's the reason why you can't ask them whether they've applied under the EU settlement scheme. If an EEA national willingly comes up to you and says, I've applied under the scheme, do you want to see my status? Then yes, absolutely you can. It's not actually a physical document, so I'm not sure if any of you have seen them yet, that it's a share code number that the EEA national will give you together with their date of birth. You need their permission to then go on online, and you will get a positive notification from the Home Office that will confirm it will show their photo and their right to work status in the UK. You don't need to apply if you were in the EU before the UK joined the EU, and also if you're an Irish national, you don't need to apply. That's not to say that they can't. They can if they want to include their family members, but they certainly don't have to. Next slide, please. So this is the difference, that they will be granted either pre-settled or settled status. As I said previously, they don't get to choose which status they get. Pre-settled status is for if you've been in the UK for 5 years. Sorry, pre-settled status is if you've been in the UK for less than 5 years, and you need to apply again for settled status to remain in the UK indefinitely. That won't automatically renew after 5 years. That's on the individual to renew that. For settled status, an individual needs to show they've lived continuously in the UK for 5 years. That includes the UK, Channel Islands or the Isle of Man for at least, they can't be outside for at least 6 months in any 12-month period, or they will lose that status. There are some exceptions to this. For example, if somebody needs to leave the UK for a serious illness or an overseas work posting or Crown servant, for example. Settled status, you can spend 5 years in a row outside the UK and not lose your status. So I'm pre-settled, it's 2 years. And any children that are born in the UK to a parent of settled status will automatically be classed as British citizens. So that is a big benefit for having the settled status. Otherwise, the children will automatically qualify for pre-settled status in line with their parents. Next slide, please. Thank you. So EU nationals travelling to the UK after Brexit, normal visitor rules, they've remained unchanged with a few slight exceptions. So EEA nationals, still non-visa nationals, so similar to US, Canada and Australia, don't need a visa to visit the UK, just turn up and show their passport, and can be a visitor in the UK for 180 days at any one time. There is talk about fading out the EU ID cards, so the needing to travel on a passport. But at the moment, as it stands, it's the ID card or the passport. And each EU state will decide the status of British nationals and what formalities are required to work or live in the individual member state, which will need to be applied depending on what a UK national wanted to do in a member state. Next slide, please. The Tier 2 intercompany transfer visa. This one is, so you've got the skilled visa, which is the one I talked about earlier, which is where the salary's been reduced and the level's been reduced for people wanting to come work in the UK, and that replaces the Tier 2 general visa. This one is for companies where they have an entity overseas that's linked by common ownership or control. So the intercompany transfer visa has been largely unchanged by the rules. Applicants need to have worked for 12 months for the company overseas, which hasn't changed before they work in the UK, or they must earn 73,900. There's more relaxed cooling off period. It used to be if you'd had a Tier 2 visa, you had to stay outside the UK for 12 months before you could apply again, except with certain exceptions. You can now switch from this visa into the skilled visa, which has more benefits. For example, it leads to settlement in the UK, which is a welcome change. The salary, minimum salary for this one is still 41,500, so that's quite a big change from the 25,600 from the skilled visa. And you can still only stay for 5 years unless you're switching, or 9 years unless you'll earn £120,000 or more. And there's no English language requirement for the intercompany transfer visa, so that it's still less requirements but more salary for the employer to pay. And it remains to be seen how many people will take up this option, given the benefits of the new skilled visa, and obviously given the benefits to the cost involved. Next slide, please. So it's important, if you're bringing somebody into the UK, you're employing an individual under the Tier 2 intercompany transfer or the Tier 2 skilled visa, that you have what's called a sponsor license first. So UK companies are required to hold a sponsor license, and this is to employ anybody from the 1st of January. Previously, if your company relied heavily on EEA nationals, you wouldn't have needed a sponsor license, and maybe something that you've never considered. For a sponsor license, the company must be eligible, and it must be a genuine business operating legally in the UK. It's evidence to, when you submit your sponsor license, all the documents support the eligibility, genuineness, and operating legally in the UK, and the Home Office can check these documents themselves via Companies House, for example. You have to have evidence of key personnel who will manage a sponsor license, so you need somebody who's an authorising officer, for example. You need somebody who will be a level 1 user who can log in, make any updates, and you need to have good HR systems in place. So these need to be able to monitor your sponsored workers. They need to be able to trigger updates onto the system. They need to be able to, if the Home Office audited your premises or audited your documentation, to show what you have in place for compliance, and that's just to show that you are taking your sponsor duties seriously. Compliance visits and audits can be triggered by, for example, not making regular updates, or they can simply just be your company has been selected. You don't need to have done anything wrong, and the Home Office can. Before COVID, they could turn up unannounced, but they are doing online audits and checks at the moment. Even if one overseas worker, you need to employ one overseas worker, then you will need this sponsor license. And from your sponsor license, you can issue what's called a certificate of sponsorship. And from the certificate of sponsorship, you can then apply for the visa for the individual. They take around 8 weeks to process a sponsor license. We have seen them coming through a lot quicker, around 4 to 6 weeks at the moment. We are expecting a rush now during these last few weeks as people try to get their systems in place and get their sponsor license in place ahead of January. And the sponsor license is valid for 4 years, after which you'll need to submit a renewal application, which is it's an online renewal box that you check and pay the relevant fee, but the work behind that is a lot more, the compliance issues behind that are a lot more relevant. So it's checking that your systems are up to date, checking your key personnel are still there, checking your authorising officer is still aware of the duties, checking any updates have been made in relation to mergers or acquisitions which should be made within the 20 working days. So it's just checking that is all in place before the sponsor licence is renewed. The current fee is it's £536 for a small business or £1,476 for larger organisations. And a small business for the purposes of immigration is defined as somebody with less, a company with less than 50 employees or a turnover of less than 10.2 million annually. Sponsor duties need to continue throughout the licence of the sponsor licence, and the authorising officer has ultimate overall responsibility for the sponsor licence. So they are responsible for who has access, passwords can't be shared, they have overall responsibility for what is going on in the business, and the authorising officer is usually somebody who is in charge of migrant recruitment. So it's typically HR managers and directors and above, but it doesn't have to be. That's just typically what we see. And any changes in relation to the individual. So just as an example of what does need to be reported, if you have a significant change in salary, if the individual will move, duties have changed but it's still within the same SOC code, if their premises will change, anything like that, the office where they work, that needs to be reported within 10 working days. And as I said earlier, if there's a change in the company structure, so for example there's a merger, there's an acquisition, there's any GP transfers or anything like that, that needs to be reported within 20 working days. Next slide, please. So just a brief note on remote working, because we get quite a lot of queries on this given the current circumstances. You can't work in the UK without the relevant work permission. So there is a business visitor category in which you wouldn't need a sponsor license, but the actual duties that you can carry out as a business visitor are very limited. For example, you can't be working on a client site, you can't be doing any what's classed as work, but you can, for example, in some circumstances, sign a trade deal or something like that, or you can provide training, but in very limited circumstances. And what we would caveat for the business visitor is that you do an assessment and you do check exactly what your individual will be doing in the UK, because the area is very grey between requiring a skilled or work visa and being able to enter the UK as a business visitor. We would always advise that there is a full itinerary, the individual travels with a full itinerary of what exactly they'll be doing, where they'll be staying, shows that they have the relevant funds and they have a return ticket back home. And that should just eliminate any questions or any issues at the border when crossing over as a business visitor. But it's very important that the business visitor rules are checked and you're confident and comfortable with what that individual will be doing in the UK. If you're not physically in the UK, you don't need a visa. We get that question quite a lot with people who are maybe working back home or working overseas. There will obviously, be maybe tax issues involved or anything like that. But in relation to immigration, if you're not working in the UK, that's fine. The visitor options can include permitted paid engagements, intra-corporate activities. But as I said, it is a grey area as what is deemed to be carrying out work and what isn't, and we would definitely recommend that you seek advice on that. Next slide, please. So forward planning for businesses, what you should be considering ahead of the changes. If you don't have your sponsor license yet and you think that you will be relying on EEA nationals from January, it's not too late to apply, and you don't need to have this in place before the 1st of January unless you wanted somebody to start in the first week of January. So if your business, you're projecting that you will need talent in the UK from say March, that's fine. You can look ahead to January, February applying for your license. As I said, even if you just want to recruit one overseas national, one EEA or non-EEA national, you will need the sponsor license in place. Encouraging EEA nationals to apply under the EU settlement scheme if they're in the UK before the 31st of December, encouraging them to apply before the 30th of June. It's not, the onus is not on the business at all, not on the employer to apply, it is on the individual, but the Home Office have produced a very useful toolkit which encourages EEA nationals to apply. It guides them through what they need to do. There's a template letter on there and it's very, very helpful. Assess your additional costs for the business. So typically a sponsored visa for 5 years now could be £9,000. The payments all need to be paid up front. There's also any dependent fees. If they're bringing maybe a wife or children, you'll need to consider costs for those that you may not need to consider before. Check your current HR practices. Do you have the systems in place for monitoring sponsors workers? Right to work checks, check whoever is carrying them out in your company. Are they trained? Are they up to date with the new changes that are coming in? This is the biggest overhaul in the immigration system since 2008, and it's important to have the processes in place from the outset, because, as I said, a sponsor license can take up to 8 weeks. So if you are thinking that you need, that talent in the UK for a certain specific role, then you should be looking ahead and having all this in place. We are expecting that, as I said, the sponsor licenses could take longer with COVID and people rushing to get the sponsor licenses in place. So it's just good practice to apply. If you do have your sponsor license, we'd definitely recommend having a health check, just carrying out an audit, checking everything is up to date and that you're confident that you are complying with sponsor license duties. And there's also very helpful government guidance on that, on what you should be doing, what needs to be recorded, what records you need to keep, and things like that. So it's useful to take a look at that. Next slide, please. So TUPE and immigration considerations. So the reason that I put this slide up is because a lot of employers maybe think of this as an afterthought. It's not necessarily changes to the UK immigration system. It's always been in place. But if you fail to notify UKVI of any changes in your business, it can result in action being taken and the permission of all sponsors workers to be curtailed to 60 days. If you have somebody working who is an illegal worker that you may not be aware of, in the UK there are criminal and civil penalties for that. A sponsor license is not transferable, so if you are receiving somebody via TUPE and you don't have a sponsor license, you need to get that sponsor license in place, and you have 20 working days to apply for that. So that must be made within 20 working days of the transfer, and then you have 5 days to submit, 5 working days to submit all the documentation. So that's the documentation in relation to obtaining a sponsor license. So it's, for example, company accounts showing that you have employer's liability of up to 5 million. These are just examples. There's a long list of what you can submit. An affidavit linking the entities if you're applying for the Tier 2 intercompany transfer, and anything like that. So it's always a good idea to get the documents in place first and then applying, but noting that you do only have the 20 working days to apply for that licence. There's duties on both sides, the transferor to report the moving workers and not to surrender the licence if they want to continue to have that licence, and the transferee to apply for the sponsor licence within the time specified period. You might want to look at increasing your certificate of sponsorship allocations. So if you have people coming to you from the UK, coming to you from another business, and you need to extend their visa, maybe it's coming to an end, you need to look at your certificate of sponsorship allocations there. And the reason for that is if you don't do it annually, there is a delay when you apply to the Home Office for one, so it could delay the any visa application quite significantly. Any changes to your sponsor license, if you're adding a new branch, for example, that should also be included. And just a note on right to work checks following TUPE. So they are deemed to be carried out by the employer who transferred across. So you usually acquire the benefit of a statutory excuse. However, there's a big assumption that the right to work checks were carried out correctly in the first place. We would always advise that you carry out your own checks, and because the receiving employer could be liable for £20,000 per illegal worker and up to 5 years imprisonment and an unlimited fine. So it's definitely worth just carrying out your own checks, but also if you have anybody who is on a time limited visa, for example, where follow-up checks are considered, you know, are mandatory, then you would be able to catch that when you were doing your right to work checks at that point. The Home Office does allow a 60-day grace period after GP transfers to conduct fresh right to work checks and to establish a statutory excuse. So that doesn't need to be done immediately, and gives you time to check, you know, check your processes and assess your systems for your right to work checks that are in place. So just a summary, the main changes to the sponsor license, main changes to the immigration system are the following the end of free movement on the 31st December, any EEA national who's not in the UK will fall under the new immigration system and will be treated exactly the same as a non-EEA national. And as discussed throughout this session, the significant costs for the employer and the additional compliance matters involved will be quite significant, and just to make sure that employers are aware of their talent and their business needs just going forward as we enter 2021. And that's it from me. Do we have any questions?
That was excellent. Very, very informative. It's so informative, Carly. There's no questions come through. You must have expanded on it so fantastically. Andy, do you just want to unmute? Can you just expand? I don't know if everyone's seen that in the chat function, but Andy, just unmute and just expand on your pensions.
It was just to add that the pensions is going to be a requirement as well, in extension to what Carly mentioned, plus the employer's liability, where it's 5 million minimum at the minute. Standard pretty much across the industry has been 10 million for the past 15 years. So, but that's likely to change probably next year, that the standard's going to increase from 5 to 10.
Thanks, Andy. Carly, would you just, I guess you've got a lot of clients coming to you over the last few weeks and months, just obviously Brexit related. What are the main questions or concerns that they're coming to you with?
Yeah, so the main one is right to work checks. We've got a lot of employers and clients that are concerned with if I employ somebody in the second week of January and they just show me their passport, how do I know that they weren't? How do I know that they've just arrived yesterday and that, you know, that I'm doing a right to work check on a passport and I'm worried I'm employing an illegal worker? That's the question that we get probably the most. And the answer is they need to only show their EEA passport or ID card for you to obtain your statutory excuse, providing it's carried out in the correct format. So it's taken, you know, the usual applies before they started work, the document, a copy was taken, or you did an electronic, you know, check online, but it would be their EEA passports, it'd be a document. Yeah. But if you, and that you definitely don't ask, have they applied under the EU settlement scheme, because they do have until the 30th of June next year. But it's just making sure that if you have anything that you're aware of them saying, you know, oh, I arrived in the UK, you know, if you have an interview set up, for example, and they say, okay, great, I'll be arriving on the 1st of January, that means they need to come under the skilled worker visa. So we've been on Home Office conferences and asked, is there anything the employee needs to do to check, you know, because we were anticipating that they'd need to check utility bills or something like that from December to show that you were living in the UK, but that's absolutely, they've said that's not the case. Also, they've said that right to work checks for EEA nationals won't be retrospective. So once you've carried it out and they've showed you their EEA passport and their ID card, then you've maintained your statutory excuse. I always say caveat, providing you carried out the correct check. But the difficulty you'll have if the EEA national's working for you and then they haven't applied under the EU settlement scheme, if they go and work for somebody else after, you know, from the 1st of July, they are then not going to be able to prove, if they haven't applied under the EU settlement scheme, that they have, you know, they have the right to work in the UK. It's just really important that the EEA nationals and the family members are applying under the scheme. And we can, as employers, can only encourage and guide them, but you can't make them, you can't ask them to check. We've had a lot of feedback from clients where people who have applied have just willingly said, I've applied under the scheme, do you need to see my right to work check? There's been no issues where people have been trying to hide that they've applied under it. It's just, you may come across, you know, that issue going forward. But also you can apply under the EU settlement scheme from outside the UK, and I think a lot of people aren't really aware of that, but you have to have been living in the UK. So just going back to your question, Rob, we've had people who have been phoning up from France, for example, and saying, I need to apply under the EU settlement scheme. We say, have you lived in the UK? And they say no. And well, you're not going, unless you're going to live in the UK in the next 2 weeks, you're not going to be eligible. But if you have lived and worked in the UK and then you've gone home for a bit and you're applying from home, wherever that, whatever EU country that's from, you can apply under the EU settlement scheme that way.
Yeah, great. Fantastic. And you mentioned, which I thought was a great point, you mentioned about forward planning, which I guess is obviously extremely important. There'll be a lot of businesses out there that are very seasonal businesses, won't there? So in terms of that forward planning, looking at the calendar, when do they need that sort of additional staff, etc., then again, I presume that's something that's quite common.
Yeah, we get that question quite a lot, and what we're saying is, and it's an important point to note, that the what's called the SOC code, which is the roles that the Home Office say the kind of duties you need to be doing, the type of salary you need to pay the individual, that has been expanded. So it's included roles like roofers and plumbers, and these roles were just not on the list before. But there is still not a list. There is still not a category for what the Home Office deem low-skilled workers. We don't know whether the reliance on EU nationals from next year, the Home Office will assess this again and think, well, maybe we do need to introduce something. But currently, manufacturers, hospitality, for example, there isn't a role for them. There is, for example, a retail manager and certain different ones like that, which we look at on an individual basis. But there is, if your company does rely on EEA nationals heavily, then the only option is that their current nationals are applying under the EU settlement scheme, so that, they can continue to stay and work in the UK. But it does mean it is a space to be watched on what will happen with that category in the UK. There's also been, just meant to mention quickly, other visa categories that the Home Office have expanded. So there's, for example, a global talent scheme, and one that people who rely on EEA nationals may be interested in is from spring next year. They are introducing the graduate scheme again, which is the similar to the old post-worker scheme. So if you've studied in the UK, you can stay in the UK to work for any employer. You don't need a sponsorship for up to 2 years. So that's people who heavily rely on EEA nationals may want to consider that route from spring next year, which will hopefully fill a lot of the gaps.
Okay, and final point, I guess, about the application process. You said that's 4 to 6 weeks at the moment. Typically, I guess, with Brexit creeping up as it is, then that could potentially increase over the next few weeks as people sort of deal with this last minute, don't they, I guess?
Yeah, and I guess the thing, I mean, the applications for people started from January opened on the 1st of December, and it was quite, we had quite a lot of applications going in. But for the sponsor license, it's around 4 to 6 weeks. But I thought it would be a lot longer given we're so close to the end now. But I anticipate probably from January people will realise, oh, I do need this sponsor license, if they're looking at their talent and what they need. So I don't know if that'll pick up again from January, and that time processing will be delayed.
Yeah, great. Andy, just on mute again, you just mentioned about transport, logistics, drivers particularly, which is always a massive point, isn't it? Again, just quickly expand on that point for us.
Yeah, it wasn't directly related, but I've had a few issues myself with some of my customers who drive outside of the UK and across Europe, which includes Ireland, of course. And what you'd have to do almost certainly with effect from the 1st of January is produce a green card. Now, insurers, this is a manual process that insurers have to process, and being that it's the busiest time of year for insurance companies and they're going to be inundated with requests, anybody that's planning on driving outside of the UK within the next 6 months, absolutely, you need to request one of those now.
The green cards are valid for 12 months, aren't they? Is that right?
Correct. Yeah.
Great. Thanks, Andy. Okay, Carly, that was excellent. Really appreciate that. There's a lot of content in there. We'll share your slides if that's okay with everybody.
That's fine.
You're on the last page, weren't they? So if anybody's got any questions, I'm just conscious of time. If anybody's got any questions, please feel free to get in contact. Susanna, thank you again very much indeed for yours. There was a lot of content on there, and I think the message from you guys is that there will be ongoing support, a lot of events, webinars, etc., going on over the next few months, and those personalised, bespoke sort of reports, training sessions, help, etc., is there, and you guys are ready and willing to help. Is there anything else, Susanna, on top of that?
Sorry.
Was there anything else sort of as a follow-up, or was that it? Really?
Yeah, so we mentioned that there will be a potential there will be a webinar next week. We're potentially putting a few more support on the first week of January, because I think obviously we'll have lots to communicate, depending on what happens today, and rectified potentially on the 28th of December.
Great. And as I said earlier, let's see if Boris can work his magic in Brussels. We'll leave it there. That's brought us perfectly to 10:30. Thank you very much all indeed for joining. I hope that's been really useful for you. We'll get all the slides, and thanks again to Kelly.
That is, of course, if we do want him to do his magic in Brussels. Some of us don't.
Yeah, true. It can work both ways, Mr. Horton. That's a very good point. We'll see what happens, won't we, over the next few days, of course. Thanks again, everybody. Thanks for joining us.
Bye.
Take care.
Cheers. Thank you.
Bye.